state liability cases actually helped it to protect consumers from unsafe drugs and medical devices because they brought new safety information to light, information the FDA might not otherwise get. In fact, in 1997, former FDA Chief Counsel Mark Porter stated, quote, FDA's view is that FDA product approval and state tort liability usually operate independently, each providing a significant yet distinct layer of consumer protection. FDA regulation of a device cannot anticipate and protect against all safety risks to individual consumers. Preemption would result in the loss of a significant layer of consumer protection. And former FDA Commissioner David Kessler testified in a previous panel that this was the agency's long-standing view. And yet in early 2006, the FDA issued a final drug labeling rule whose preamble announced a brand new position. The preamble declared that the agency now believed that FDA approval of labeling preempts state failure to warn lawsuits. And in that preamble, the FDA claimed that the preemption is the agency's long-standing position. So you'll have to forgive me, Dr. Lutter, I'm a little confused. We know from our previous witnesses that the FDA's long-standing position was against preemption of state court cases, yet your agency now claims the opposite. Please tell us the date and time when the FDA decided to reverse its long-standing position on preemption and the persons involved in that decision.
The position on preemption has been articulated in a number of amicus briefs over the years and also in various regulations in their preambles. With respect to the positions pertaining to statutory law, these go back statutory law by the states, these go back all the way to the 70s, and there's been, I believe, no change with respect to FDA's position on preemption in that regard. I mentioned in my oral testimony several regulations where preambles have articulated a position on preemption that goes back a couple of decades. I'm not an attorney by training. I have been briefed on the matter here, and I come to you as a representative of FDA and its current policy position on preemption.
Well, are you aware that long before the FDA was ever created by act of Congress, that state tort liability claims involving medications and drugs and drug devices were already taking place?
Yes.
And did you have to take an oath when you became Deputy Administrator at the FDA?
Yes.
Did you have to swear to uphold the Constitution of this country?
Yes, sir.
Are you familiar with the Constitution?
Yes, sir.
Including the 7th Amendment?
Yes.
What does that provide?
I'm sorry, I don't know the 7th Amendment.
The 7th Amendment provides that in suits at common law, which is what we're here talking about today, the right to trial by jury shall be inviolate. So can you explain to me how it is that the FDA has suddenly decided that it is going to completely turn the doctrine of federal preemption on its head by having federal agencies stand in the role of Congress, which normally has the exclusive jurisdiction to preempt state law claims?
I think there's also a supremacy clause sort of in the Constitution that deals with the relationship between federal law and state law. And the supremacy clause speaks also to the question of FDA's authority relative to other authorities exercised by state law.
The supremacy clause of the United States Constitution, you claim, speaks to the FDA's authority?
It speaks to the relationship between federal law and state law.
Because you realize that the FDA did not exist when the supremacy clause was added to the Constitution.
Yes, sir.
And in fact, that was one of the whole points of the Constitution and the Bill of Rights, was to distinguish those issues where the states had the right under the savings clause of the 10th Amendment to exercise their control over things like product safety. Were you aware of that?
I'm aware of the 10th Amendment, yes, sir.
Now, one of the things that we're concerned about here is it seems to us that the FDA has changed its position on preemption 180 degrees, because we know that there was a preamble to the final rule on drug labeling, but the proposed rule was issued back in 2000. And there was absolutely nothing in the proposed rule that signaled that FDA intended to address preemption, much less that the agency was going to reverse its long-standing position. So can you tell us what happened between the issuance of the proposed rule and the later final rule and the change in the preamble?
We received public comments asking us to articulate a position in this regard, and we took those public comments into develop the language in the preamble based upon those.
And did some of those public comments come from agencies or associations or trade groups who have been at the vanguard of the tort reform movement?
I presume they come from a variety of sources, including industry.
Including bodies like the American Enterprise Institute that you work for?
I don't know if the AEI filed a brief. I did work at AEI. I was not involved in